Right, greetings. So this is the second part of this lecture on the idea of animal rights laws. We saw in the first lecture the sort of ideas that groups were coming up with, some of them quite straightforward, some quite simple concepts, some of them were concepts designed to really make a very bold statement. What we're going to do in this lecture is to drill into the detail and really see, to some extent, what sort of ideas we've talked about for rights and what they might look like in law. So some of them are going to be quite short, because what we're trying to do is say, okay, let's accept this as a right. What would it mean? What are the implications? And of course, most of the things we looked at in the previous lecture were quite broad. They were general phrases. They used words like necessary or unnecessary or appropriate and so on. And of course, that sort of language tends to lend itself more to international treaties and to constitutions. And so what we're now going to see is what specifically might some of them look like. Okay, well, we talked about dignity. Dignity, the foundations, as we were talking in the break, it's foundation of human rights, the justification. Human dignity is what justifies having human rights. So, in principle, it fits in intrinsically with humans. Arguably, it's a human design concept. So the question, as we touched on, is can we grant the same recognition to animals? If we give dignity, we recognise the dignity of animals, is that going to achieve anything or not? So is it applicable? And if it is, what sort of benefit it will provide? So it could be quite a straightforward concept. Animals should be treated with due respect for their dignity, or animals should be treated with dignity. It's a very basic notion. Is it going to achieve anything? We could narrow it down. Animals could be treated, or be more specific, should be treated with due respect for their dignity. The following activities shall not be consistent with dignity. So we're taking this basic phrase and saying, and here's what it means. Here's specific situations. I've just given a relatively simple one, entertainment in circuses and zoos. We could add factory farming. We could add animal experimentation, which uses animals as means rather than ends. So it could be you take the concept of dignity and you give it more teeth because you make it more specific. In other words, classic fundamental law drafting, the more that you define something, the more specific you are, the more it's relatively easy to see whether you're in compliance or in breach, and the easier, if you're in breach, it is to enforce. Remember, going back to some of those welfare laws in the first term, where you were talking about welfare laws about necessary and suitable, and do you remember the ethological needs of animals? Well, what are those? It's either a great phrase or it's a useless phrase. And you need to bear that in mind. If you've got an enthusiastic judiciary, enthusiastic civil society, then these are great phrases because they have so many implications. But we also know that if you have reservations from civil society or the judiciary, it becomes very much harder because you go, well, does this actually apply here? Does this really work? And just as you remember, we had ethological and so on, and suitable in welfare. We also had, you remember, how wide the slats should be, how large a farrowing crate could be in metres. Very detailed, very specific, very narrow, and yet very enforceable. And so the idea of taking this concept of dignity and extending it so that you can go further with it and really spell out what it might mean. And obviously it's a very short list. I've only given one example here, but you could list a whole number of examples to make this work. Property. You remember from some of the previous lectures the idea of animals as property. Can animals still be property, and is that consistent with having rights? Or is it simply incompatible? In other words, is it got any meaning for animals to have rights if they're property? And this sort of de-reification idea. And you remember David Faber talked about the idea of a special form of property, where he argued that you could have living property as a fourth category. So this question about, should animals be property, or should they be not property, or should they be a special form, has all sorts of legal implications. It's good to talk about it conceptually, but the impact of it is going to be quite fundamental. If animals are no longer property, they can't be owned, they can't be sold. And again, a huge number of implications in terms of ownership, in terms of or lack of ownership, in terms of theft, in terms of damage, in terms of taking, and so on. How would we do it? Well, animals shall no longer be treated as property. That's pretty much all you need to say. An animal may not be owned nor titled to an animal transferred. If this seems strange, just substitute person or child. And you go, yes, of course they can't be treated as property or title transferred. So it's not a difficult one. The second one is taking up David Faber's point, the idea of animals recognised as living property, and then of course one would have to explore the implications of living property. I think I included I think we've got the David Faber's book and certainly some of his articles on our reading list for previous lectures, and so you can explore his ideas of living property. So it would be essentially sort of self-owned and beneficial ownership and so on, or just a distinct form of property. And again, if it's living property or a distinct form of property, one would need to set out what that means by being distinct. Personhood. Again, huge debate on personhood. And this is the idea of personhood in a much broader sense than simply being a person in a statute. Remember some of the cases we looked at on theirs where the court said, well, look, this act applies to persons. All persons may, have the right to be heard, taken into account. Nowhere can we find in any precedent or any statute that person means someone, something other than a human person. We cannot find it anywhere. There is no precedent. There's nothing in the statutes or in the laws. Therefore, persons in this law means human persons. But if you remember, they then went on very helpfully and said, if, however, the legislator would like to include animals and the definition of persons, they can do so. They can simply do so. Anyway, the idea of personhood, the basis for having rights. Is it a purely technical, juridical device, a legal fiction? But very much the debate of animals and personhood, and obviously not just the legal, but also the moral and psychological aspects. All sentient animals shall be regarded as persons in law. I'm not sure you need to say much more. So they're persons, so whenever the word persons appear, that would include animals, which of course then has implications for locus, has implications for victims, has implications for all of these sort of notions, because you've suddenly simply imported it. Now, obviously, I don't want in any way to suggest this is not trivializing the huge and ongoing debates about persons and personhood. It's simply saying, from a legal point of view, if you wanted to change the law, how would you do it? And I'm simply saying, from a legal point of view, it's these sorts of phrases that would do so. And as I say, with this case you remember from last term, where they said, yeah, if the legislature wants to include animals as persons, they can do so and we'll follow it. The great thing about the law is that it can deem all sorts of things. It can deem something to be a legal person. It can deem, a trust or a corporation. The law can do this. We can say, these shall be regarded as falling into this category. It's a relative, obviously there's a public issue with civil society and support and all those things, but from a strictly legal point of view, it's a relatively easy thing to do. Now, you could do it as all sentient animals, or of course you could narrow it down and just recognize specific categories. Subjects of law. The idea of non-personal subjects of law is quite an interesting other way of coming at this, and I put this on your reading list, which is not quite breaking the person barrier. It's the idea that you have an interest in being heard, and the idea of becoming a subject of law, a non-personal subject of law. The right to be taken into account. Now, you remember this harks back to what we saw with things like the Finnish principles. The right to be taken into account, or to have one's own individual interests considered as relevant. You remember the Finnish one talked about the idea of where things were affected, you should be heard. To have one's own individual interests considered as relevant to all decisions that may affect their realization. So the fact that you have an interest, and I also quite like the idea of one's own individual interests. So this is again the idea of animals as individuals rather than just in a group, en masse. We're not talking species or groups or anything like that. So I really rather like that one. Another way of coming at it, Donaldson Kimlicka, you've probably read now, the idea of the animal's agency, the idea that animals are perfectly capable of living complex lives, social lives, having preferences, expressing those preferences, having autonomous living with choices about how they should be able to live. So the idea that we have to decide, that humans have to decide everything for animals, they argue is simply not true. That what we need to do is to find ways of listening to them, to find ways of working with them. And then we can, adapt around them and live together in a meaningful way. And so the idea that they would live alongside, and as you probably read this in some of Donaldson Kimlicka's work, the idea of living alongside, they're agents, they've got their own views, their own preferences, they're members, they're co-creators. And when I first read this, I thought, wow, it's really hard to sort of digest it. But again, this idea of destination and direction of travel, the idea that one's willing actually to take those things into account, actually to recognize that animals have agency and preferences, and should be co-creators rather than simply recipients, which of course then links into other ways that we view animals, and that it is us who decides how animals should be living. What would the law look like? Every animal has a right to participate in the community in which they live, for their views to be heard and their interests to be respected. It's not difficult law. The right to participate. So we don't just mean, well, this road is going to affect this, these nesting animals or these particular burrowing species. They have a right to participate, for their views to be heard. Yes, of course, there's huge implications about how you hear the views of every animal. Huge implications. But again, if you think it's extreme, just put the word person in. And then it becomes much simpler and much more obvious. For their interest to be respected. Again, lots of issues. Respected how far? The point we talked about earlier on. The where there's a conflict between human interests and the fundamental rights and animal fundamental rights, the human's fundamental rights will take priority. But for their interest to be respected is not the same as priority. It's simply saying, to be taken into account, to be respected, i.e., to be considered and to be seen as part of the decision-making process. So that's the sort of way I think one would introduce it into the law. Not at all easy by any means, but equally not impossible. Standing in court, so coming at this from another direction, you remember the locus-standi problems we touched on. Right, a prerequisite. I mean, obviously, the right to appear in court isn't a right. Is a right to appear in court and argue your case. So some people suggest it's a procedural benefit rather than a right in itself. So in other words, it's the right to be heard. And as we've seen, that it's routinely denied, and often laws only recognise persons, as we said, defined as human persons. All animals shall have legal standing. So in other words, you just take away the locus problem. I mean, the locus problem, as you know, was introduced to avoid frivolous cases, to avoid too many people sort of piling in and in cases that really don't affect or apply to them. The irony is that in some of the cases which have been rejected, the animals are directly concerned and have a direct interest in the outcome of the case, and they're not, and their standing is not recognised because of the legal process and the definitions used. So animals have legal standing, right to be heard should be exercised by their legal representative. You remember Naruto a couple of years ago, where the organisation PETA brought the action on behalf of Naruto, claiming intellectual property rights in that photograph. Or animals shall have the right to be heard in any case directly affecting them. So a somewhat narrower approach, not just saying legal standing in anything, but saying where there's a case directly affecting them, they have the right to be heard. We've seen some examples. I think you had a talk a year or two ago about representatives in animal cases in the States, wasn't there? In animal welfare, or cases where the idea of someone representing the animal. So, it's not a ridiculous idea. The idea of someone in a case, whether it's a dangerous dogs case, whether it's a family law case, the idea of someone representing the dog in a case directly affecting them. Well, if it might involve the dog being put down, yes, the dog has a direct interest. Now, is the dog's case made? Sort of. But it could be done much more plainly. And again, it's recognising that the animal is an agent, has agency, has choices and decisions. Right to life. Well, so I'm suggesting that the right to life is the most important right. Obviously, you may feel differently. You may feel there's other more important rights, but it's got to be sort of up there. And so the idea is that if you had a right to life, you'd be protected from slaughter for food or bodily parts or experimentation to the point of death. So, should animals have a right to life? Every animal has a right to life, protected by law. And again, relatively straightforward. And again, fairly obviously, insert the word human and it becomes self-evidently obvious. The idea of protecting, so the law would protect the risk to the life of an animal. Obviously, I didn't go into the detail here, but obviously one would have to differentiate between the right to life in a human interactions and the right to life in the wild or in a natural habitat. Because I think we probably touched on this at the very beginning, all of these rights, animal rights cases, are not about interfering in natural habitats and protecting. So this isn't about protecting a prey animal in a natural habitat from being attacked by another animal for food. Deprivation of life, where the animal is a danger to the lives of humans or other animals, or in the best interest. So again, just working through what that right to life might mean and when it can be taken away. So the idea of, in what sort of circumstances can it be taken away? And as you can see, not going down the path of necessity or necessary or something like that. Very much focusing on the animals, recognising they may be a danger to themselves or to the lives of humans or other animals, or it's in the best interest of the animal. The idea of a right worth living, we've talked about before. As a sort of general phrase, this goes beyond the idea of life itself, and it's about welfare, it's about quality of life, and arguably, it is a goal of animal welfare, and a lot of animal welfare laws reflect an attempt to achieve this sort of outcome. It is somewhat vague, although, as I say, one could draw on quite a lot of animal welfare laws to give you a sense of how one would achieve it. So it's to do with food, companionship, family, access to medicine, access to shelter, all of those sorts of things, opportunity to exhibit natural behaviour, and so on. So it may be too vague a concept, I don't know, but it's certainly one that's been discussed. Anyway, every animal has a right to a life worth living, a good state of welfare. I put in the definition, I think it was from the EU, I've got the reference, about animal welfare, how an animal is coping with conditions. And a good state of welfare, as you said, healthy, comfortable, well-nourished and so on, able to express innate behaviour. So a good state of welfare as a legal right. What sort of implications that would have? It's something which is obviously not so far away from human rights. We've seen human rights trying to achieve the same sort of thing. Again, same sort of idea, just going a little bit more detail. The ethological, again, you remember all this from welfare, ethological, physiological, suitable and sufficient food and water, exercise, socialization. This is just pure welfare stuff. Does it make a difference making it a right? Well, we talked about this in the last lecture. Is it just the same rules, but one of them has to be provided under an animal welfare paradigm, or this is a right that animals are entitled to under an animal rights paradigm? And as I say, what's interesting is that a lot of the welfare rules seem to fit quite nicely into a rights regime. Bodily integrity, again, we've covered this before, and it's obviously quite widely accepted in human medical law. So David Feldman here, the right of negative liberties, freedom from physical assaults, torture, medical or other experimentation, immunization, and compelled eugenic or social sterilization, and cruel or degrading treatment or punishment. Obviously this has some issues. At one level it would seem quite a sort of straightforward right to grant. If you were to explore this, it would have presumably fairly immediate implications for animal experimentation. It would also, of course, however, have implications for other things such as neutering and spaying of wild dogs and cats, or something similar on wild populations where there's an overpopulation. So when, again, you could grant the right quite easily. It's not a difficult one. We understand, from Feldman and others, what a right of bodily integrity means. So granting a right to it isn't difficult. Obviously, you'd need to think about the extent to which, or circumstance in which case it can be taken away, so medical treatment. I've started to put in here where the animal is feral or wild, medical treatment is sterilisation, approved policy to deal with overpopulation. So you could introduce the right and then start filling with things that we regard as the right thing to do. They may be transitory. Where people have argued for a right to family life, for example, that has issues, obviously, for wild populations and controlling wild populations. And it may be that's something that, although we would almost certainly not do in the case of humans, it's something which perhaps we regard as more acceptable for animals because of consequences. But again, from a legal point of view, it's not too difficult to introduce. So as I said, family life. Donaldson and Kimberley again, many animals indicate a strong desire for sex and parenting, given the freedom to be able to act on these desires without significant health risks to themselves or their offspring. But as I said, that has wider implications in terms of controlling wild populations, both in city and town environments, and also wild populations in the wild, where a particular species is simply becoming too dominant and having effect, say, overpopulation and therefore the risk of famine, or driving out other species, or overgrazing, overuse of plants and trees. So that may be something, while if one applies the human test, would seem a very obvious thing to grant, perhaps comes into conflict with people who would otherwise support these sort of programs. But the fact is, if we're going down the path of granting rights that aren't dissimilar from human rights, the right to family life would appear to be quite an important one. So how we would deal with that is not clear. Social membership, recognition of family membership, a membership relationship. So this is the idea of domesticated animals in families. And what he's suggesting, what Kimberley is suggesting here, is that being part of a family is a different relationship rather than the sort of owner, master, mistress, pet idea, that it's much more a membership and participating in that membership. So you are much more participating in terms of ideas, decision making, and all those things. This quote is where I think it was a particular town audience.
We won't be much longer, but sorry, are you waiting to enter?
No, she doesn't close at 7 usually.
Building is closing.
Yeah.
Right.
What time?
It's supposed to be closed already.
Oh.
I can wait to
Sorry,
see
Julie.
10 minutes?
We can take the back exit if that makes your life
No,
easier.
that's good,
Yes, we can do that.
Excellent.
Yes, okay.
Then it's fine, right?
Okay, sorry, Julia.
No worries.
Yes.
Take your time then.
You're immortalised now, by the way.
So we close the front door and just go out.
That's great. We'll take the back exit. Okay.
Okay.
Bye-bye. Thank you.
Thank you. Sorry, I didn't realise that we were after closing. So residents include dogs and cats. This was a city ordinance, the town ordinance, where they said, yeah, so residents need to be taken into account, and we include dogs and cats. Really interesting idea. Again, the idea of this single unit. Right to be a co-worker. Again, very interesting. The idea of a police dog or an army dog, drug dogs at airports and so on. The idea of them being co-workers, rather than simply, we use a dog to sniff out drugs or explosives or something. And animals as co-workers. I think David Faber gives the example of police dogs in the UK getting pensions. and that idea that these are all workers and some of them are human workers and some of them are dog workers. It has some other implications because, of course, it's not entirely clear whether that co-worker animal has consented and what that consent means. And if you're interested, there was a very good talk given the other week in the centre that Raphael organised with actually one of our visitors on the nature of consent. And also one from our conference last September about consent and assent. So, but the idea of being a co-worker, again, is a levelling process, that you're an interspecies workplace, which we don't think like that. We think, well, you know, this is run by policemen or something, police officers, and they have a dog, rather than imagining the workplace itself as an interspecies workplace. Really interesting idea of changing the dimensions, changing the sort of shape of it. And then, of course, what that would mean in terms of how the co-workers are treated and how they're integrated. But of course, you've also then got the question, well, how far does that go? Does that go, you know, is it limited? Can farmed animals be co-workers? If you keep sheep for wool, are they co-workers giving wool or not? We saw this one before in the Swiss situation, as I mentioned. The right not to be kept in a factory farm. Now, it's quite a narrow right, quite specific. But, of course, from a legal point of view, it has a lot of advantage because it's very clear whether the right has been breached or not. So, you know, the right to family life and interspecies work environments and so on can be quite general. This can be very specific and really quite enforceable. We know what factory farming means. There are plenty of definitions around. And so the idea of a right not to be in one and granted as a right should have enormous implications and be relatively easy to enforce. Now, obviously, as I mentioned, you know, if animals had other rights, then this one would disappear. But I think it's important to see these rights as not necessarily additive. These might be different rights. So you might get a situation where one might decide, or a country jurisdiction might decide, they're going to go for one particular right. This is very much the sort of Stephen Wise strategy in Non-Human Rights Project. He wants to get some right. And he keeps telling the court, well, it's just a very little right for habeas corpus for just one little elephant. Where, you know, and it's the same idea that just get some right for some situation, and it can then go from there. Every animal has a right not to be kept in factory farm conditions, and as you see, we've got a definition here from the EU. Farms where animals are kept substantially indoors in large numbers and managed by automated systems. So, from a law-making point of view, a law-passing point of view, perhaps, it's not difficult. Really not difficult to pass the law. Same sort of idea with this one, the right not to be used for experimentation, really quite narrow. Again, people might find it more acceptable where a country wanted to start introducing rights in an area where there was public support. But we saw the Swiss situation earlier on. Again, from a legal point of view, a right not to be used for any experimental or other scientific procedure. Could be very general like that. You just can't be used. Or you might want to qualify a little bit, right not to be used in experimental or other scientific, which may have the effect of causing pain, suffering, distress, or lasting harm. So that might be seen as a suitable middle path for countries that wanted to protect animals from experimentation, where, and as you may recall from last term, you know, experimentation has to be registered and regulated and so on, and there are different categories of experimentation. And what the second one is saying is, well, why don't we just, at least protect animals from the ones that cause severe harm and Right to own property. Yes, you remember the Naruto case. So what they were arguing was that Naruto should own the IP, the intellectual property, in the photograph. Now, the right to own property, it could just be, as I say, an intrinsic aspect of personhood, being a person, or it may need to be expressly given. I think, I'm not sure that's entirely clear yet. One may say, well, it's intrinsic to personhood. But, we have human persons own property, legal persons own property. The whole point of the corporation is for them to own property. So, from a legal point of view, there's really no particular barrier for an animal to owning property. If we'd said persons and natural persons and human persons are all the same, and that's what you have to have, those criteria, then it would be much more difficult. But the law has already decided that they can create or define or specify an entity that is capable of being a legal person. So, as you've seen before, if you can do it for that, you can do it for anything. And therefore, animals can be brought within that. Animals have the right to own property. Again, not difficult. Huge implications about what you do with it. My guess is that one would have to be talking about things like, the equivalent of guardianship and all those sort of things, to ensure that the property is managed and so on in the best interest of the animal. I think in the Naruto case, Peter was going to use the money and was going to give it to the sanctuary or give it to the area where Naruto lived, which would therefore be for the benefit of Naruto and the other animals living there. So that was their proposal, which they put in the case. So it would have implications that would need to be dealt with. But again, these are not difficult. We are used, from a legal point of view, we are used to dealing with persons who own property, but who are unable to make decisions themselves about that property, and therefore need someone to make decisions on their behalf. The system is already there. Protected habitat we've come across before, fairly straightforward, again quite loose. Essentially, the rights for wild animals, as we've seen, tends to be by staying away. But of course, to grant rights for wild animals by protecting habitat, you need to impose rules on landowners, either saying that that they don't own the land, or if they do own the land that's a habitat, that they have to limit their activities. So I use this phrase: animal wilds have the right of autonomy and to have their habitats and ecosystems protected by law. Unlike some of the other ones I introduced, this is very much a sort of starter and would have to be explored, not only what the right of autonomy is, you'd probably have to add to it by not being caught, not being interfered with, not being captured, not being killed, and then what protected by law would mean. I won't go into these other ones. These were just a few. To be free, not restrained, again, enormous implications, but not a difficult one. Fair labour and the fruits of their labour. Again, a recognition of the fact that if we don't own animals, if the law changes and animals are not owned, how you work with them, you're going to have to bring in things like, sort of multi-species workplaces, have to deal with issues like consent, have to deal with issues like fair conditions, and the question of the fruits of their labour. And then one or two, not to be used for breeding, not to be exploited, abused or killed. These are potential rights. And one I got from a set of principles, to be rescued from situations of distress and exploitation. They have a right to do that. So it isn't, you're no longer, forcing groups to stay outside and hope something happens. You're actually entitled to go in because of those rights. So what we've done is really try and distill many of the concepts we've talked about and say, well, what would happen if it was a law? And I think hopefully what we've seen is that it's relatively, in many cases, it's relatively simple. Yes, of course, it generates further questions, and sometimes will necessitate subordinate legislation to go along with it. But one can take these very big ideas and introduce them into laws relatively simply. Thank you very much.
At the bottom.
Oh, yeah.